Following the examination for discovery, the case must be mediated. Effective January 1, 2010, every lawsuit commenced in the City of Toronto must be mediated. What is mediation? Mediation is a form of alternate dispute resolution. It's an effective way of resolving disputes short of trial. In essence, it's a settlement conference. With the aid of a mediator, generally a lawyer but not necessarily a lawyer, the parties meet in an effort to resolve the case, narrow the differences, and arrive at a settlement. Mediation is a very successful way of resolving cases. What happens on mediation, and what do we do? Prior to mediation, we'll meet with our client, discuss our mediation strategy, discuss the whole process, and explain what our bottom line settlement figure will be and what we hope to achieve at mediation. It's important for every client to be empowered, to be informed, and to be aware of what's involved in their case. Remember, you, the client, it's your case, not the lawyer's, it's the client's case. And because it's the client's case, you have every right to ask questions, to be informed, and to know what the negotiating strategy will be. Mediations generally take about 6 or 7 hours. You should plan on spending the whole day at the mediation place. Generally, mediations take place sometimes at the mediator's office or in an office building where there are rooms set aside for mediation. And what happens in mediation is this. We all meet, that means the parties, the lawyers and the person suing and the insurance company representative meet in a room. That's called a joint caucus. And the plaintiff's lawyer, in which case me, will make a presentation, generally 15 to 20 minutes, outlining the essential features of your case. Prior to the mediation, a detailed legal brief is prepared with a mediation summary containing a written summary of the case, together with all the various medical and expert reports and other documentation necessary for the other side to understand your case. We also are served, and you're provided with a copy of the other side's version of the event. But at the mediation, I will make a presentation. I will advocate on your behalf why your case is important, why you deserve compensation, and I'll highlight the important features of the case. Following my presentation, the other side, usually the insurance company lawyer, will present his or her arguments about the strength of their case and why your case isn't as good as we say it is, or as strong as we say it is. Following their presentation, I will generally make a brief rebuttal, and then we will conclude what is called the joint caucus session. After my remarks, I'll ask you to say a few words about the effect of the accident on you, your family, and on your career. It's very important that the insurance company representative, the adjuster, understands what you've been through. The adjuster has not met you. The lawyers have met you, but the adjuster has not met you. So it's important for the settlement of the case that the insurance company representative, the insurance adjuster, or the claims examiner or claims representative understands what you've been through. So I'll ask you to say a few words, to tell from your heart what you've been through. I'll also ask for one of your family members to speak as well on your behalf, to explain to the insurance company what you've been through as well. In my experience, the most powerful statements are those coming from family members, as they attest to the trauma, the suffering, the ordeal that you've gone through. So it's important when you attend on a mediation to be well prepared, to understand the process, and to be willing and able to speak. If you're not able or you're hesitant, then it's important that a family member speaks on your behalf. Remember, this is not a trial. This is an out-of-court settlement meeting, and that the goal is to obtain the best out-of-court settlement that is possible in the circumstances. After you conclude, the other side will be given an opportunity to tell their version of the case and to offer their views of the theory of the case. Following the defense lawyer's submissions or comments, I will generally have a brief rebuttal to make about some of the points that the lawyer has made in his or her presentation. After the presentations are concluded, the group splits up. You, the client, and your family member, myself, and one of the other members of our team will go into one room. The insurance company representative, the defense lawyer, will go in another. The role of the mediator is to act in a way as a go-between, to understand each side's position and to help each side arrive at a consensus, which in this case means a settlement. This is what happens. The mediator comes to our room, and we will present the mediator with our first settlement proposal, the first offer. Now, the first offer is one that we've discussed in my office prior to the mediation when we discuss our negotiating strategy. In my experience, no mediation should be attempted unless the client is fully informed of what the negotiating strategy is and what the end game is as well, what the final achievement ought to be. So when we meet with the mediator, we will start with an offer which has been worked out well in advance. We present the offer to the mediator, and you will be asked to sign a document outlining your acknowledgement of the offer. So you participate every step of the way. The mediator then goes to the other side, presents the offer, and comes back with a proposal. And it could go on for many, many hours. Finally, one side or the other will accept the other side's proposal, and the case will be settled. Not every case settles. I've done many, many hundreds of mediations, and the vast majority settle at mediation. If they don't settle at mediation, they may settle shortly before trial. But mediation is still the most effective way to resolve disputes. It's cost-effective, and it's much, much less stressful than a trial. We spend a lot of time on mediation. We spend a lot of time preparing you for mediation, and we spend a lot of time preparing our briefs, which is written advocacy, which is a written summary of the case. In our experience, preparation is critical for success. The better prepared you are, the greater chance you have of achieving an appropriate result. If the case settles at mediation, generally within 2 to 3 weeks you'll be provided with settlement funds. At mediation, you will likely have to sign a release, which means the case will be finished and you release the other side. And in a few weeks, or as I mentioned earlier, you'll be provided with the settlement funds. And that's how the process works.